or thinking what.
I've added a little bit of new material to hold your attention.
She didn't pay attention the first time.
Yeah, an apology to Ross Davies, because I'm not going to say anything he doesn't already know. A disclaimer: I'm going to be talking about a legal topic. This is not legal advice. I am not representing you in any Sherlockian project you may be engaging in. But a more friendly disclaimer. We all know the law is complicated, the law is difficult, the law is abstruse. A lawyer can give a talk and no one will know what he or she was talking about. Actually, all the concepts we're going to be discussing today are relatively straightforward. If there's anything you don't understand, it's because I didn't explain it well, not because the subject matter of this particular talk is inherently complicated. Lastly, I'm only going to be talking about American copyrights, only U.S. law. And lastly, for those who were at the BSI dinner, Betsy Rosenblatt gave a talk on copyright. I'm not really going to be overlapping much with what she had to say either, other than maybe a couple of bottom line results. However, if by some happenstance anything I say disagrees with anything she says, I'm a dilettante in this area. She's a professor of intellectual property law. Ignore me and listen to her. So if everyone agrees with those ground rules, which are probably exhausted the time for my presentation,
I was going to say, your time is up.
we can get started. Sherlock Holmes and copyright. A lot of you have been reading over the last few years about how Sherlock Holmes is now in the public domain. The very last of the stories in the casebook of Sherlock Holmes are now in the public domain in the United States. Anyone can reprint them, anyone can adapt them, anyone can use them, and that wasn't the case. That wasn't always the case. There was a time when various of the Sherlock Holmes stories were under copyright, and there were very sharp restrictions on what we could do with the stories. A fact that is not generally appreciated is that Sherlock Holmes and Dr. Watson, the characters, as opposed to any particular story or group of stories, were never copyrighted in the United States. How can I say that? How can I say that? When did the stories start to be written? Study in Scarlet, published 1887. Sign of Four, published 1890. In 1887 and 1890, to get a copyright in the United States, you needed to be an American citizen, or at least an American permanent resident with the intention of becoming a citizen, or a company owned by such a person. A British subject, such as Arthur Conan Doyle, was not eligible to acquire a copyright in the United States on anything he wrote. This was not, by the way, an inadvertent gap in the copyright legislation. This was a very deliberate decision by Congress that we wanted to preserve intellectual property rights for Americans. We didn't have any great incentive to protect Charles Dickens' copyrights or Gilbert and Sullivan's copyrights. To the contrary, the American printing industry, the American publishing industry, and even the embryonic printers' unions very much like the idea of there being a great body of English language works, fiction, nonfiction, works of all kinds, that the Americans could print without having to pay any remuneration to the British or other foreign author. Who was disadvantaged by this system? The American authors, led by Mark Twain, who were not getting any remuneration when their books were printed in England or on the continent. And so there was discussion for years about whether there should be some sort of intellectual mutual copyright recognition, but by the 1880s that had not happened. You've heard about pirate editions of A Study in Scarlet, pirate editions of The Sign of Four. If any of you have seen Glenn Marenker's exhibition or looked at his catalog with 3 or 4 of the literally dozens of so-called pirate editions of these books that appeared. And they're called pirate editions because Conan Doyle didn't authorize them. Conan Doyle or his publisher didn't get any remuneration from them, but they were not pirated in the sense that they were illegal. It was perfectly proper and even encouraged to do this. Well, eventually the authors were heard, and in the beginning of 1891, Congress passed an International Copyright Reciprocity Act. It was called the Chase Act after Senator Chase of Rhode Island, who sponsored it, and it empowered the president to negotiate international copyright recognition treaties. And the first one that was enacted was between the U.S. and the U.K. It took effect on July 1st of 1891. Now that is interesting timing, because does anyone remember when A Scandal in Bohemia, the first story in the Adventures, was published? Was published in July of 1891, and there was actually a letter from A.P. Watt, who was who represented Conan Doyle in his literary affairs. He was the literary agent's literary agent. A.P. Watt wrote to the Strand and said, you know what, don't publish this in the June issue, hold off till July so we don't endanger the American copyright on the series. They then, in order to register a copyright, now that it was permissible, you had to follow certain formalities. You needed to send 2 copies of the story to the Library of Congress, along with a fee of $1, and fill out a form. A Scandal in Bohemia comes out, the Red-Headed League comes out. Nobody remembers to do that. Those stories fall into the public domain too, and you'll see pirated editions of them. There were 12 stories in the adventure. McClure, which was doing the magazine serialization, eventually remembered to do this, but according to an article that Matthias Bostrom published in the Journal a few years ago, years later when somebody did a copyright search for the film industry, between the registering it, submitting it properly, and renewing it, something like 10 of the 12 copyrights in the Adventures were botched. And theoretically those stories, if anyone had made an issue of it, could have been used by anyone as well. In any event, between 1891 and 1892, 12 stories in the Adventures. Between 1893, 12 more stories in the memoirs. People think they're under copyright, at least most of them. How long are they under copyright? Copyright in that period was originally 28 years, and then you could renew for another 14 years. In 1909, it's extended to 28 years, you could renew for another 28 years. So a copyright, and it's measured from the first publication. If the story appears in a magazine, and then a couple of years later it appears in a book, the clock starts when it first appears. So 56 years from 1893, let's say, is 1949. And for later stories, it's a later date. Why is that 1949 date interesting? Well, how many of you have a copy, or at least have seen the limited editions version, limited editions press version of the canon? Those beautiful volumes that were collated by Edgar Smith, who made every effort to recover the original wording, the original punctuation, put the stories in the correct order, and brought them out in beautiful volumes. And they had been working for years with the Conan Doyles. Arthur Conan Doyle is deceased by the late 1940s, of course, but they're working with Adrian Conan Doyle, Dennis Conan Doyle. They're impossible. They can't get the rights, and eventually BSI Press, the BSI and Limited Editions Press just say, the heck with it. We're going to bring out the first 4 books that are not under copyright anyway. And if you look in the first volume, the first volume of that series that came out in the 1950s, you will not see any copyright information except for the introduction that Edgar Smith had written and that Vincent Starrett had written, which are copyright to the BSI, because they said to the Conan Doyles, we don't need you anymore for that. At that point, the Conan Doyle said, well, we wanted to get a royalty. Well, if you publish the rest of we do acknowledge we need to pay you a royalty on the rest of the stories. And if you look, the rest of the series come out in 1952. Afterwards, please. We will pay you a royalty on then. It looks like it was all published at one series, but if you look closely, it's a couple of years apart because they were anyway. So it's not. Conan Doyle kills off Holmes, we think, in the final problem, 1893. Brings him back in The Hound, 1901, 1902. other stories through the 19-teens, through the 1920s. The copyright is 56 years. So the copyright for The Return expires in the 1960s. The copyright on parts of His Last Bow expire in the 1970s. And then Congress extends the copyright law. There was a long debate about how long copyright should last. And it's extended to 75 years, and then in 1998, in what's officially called the Sonny Bono Copyright Act. Bono was a congressman at that time who had sponsored, he was also a songwriter and was strongly in favor of creator rights. It's also called the Disney extension because Mickey Mouse, the character, was about to go into the public domain. And so in 1998, the term of copyright protection is extended for works that already exist. There were completely different rules for newly created works, but for works that already exist in 1998, the copyright term is extended from 75 years to 95 years, provided the copyright hasn't already expired. If that work has already gone into the public domain, it stays in the public domain. If the work has not already gone into the public domain, it gets another 20 years of protection. There were 20 years when nothing entered the public domain in the United States. So you hear sometimes about the last 10 stories, the stories that for many years could not be used. Why those particular stories? Well, if you do the math, so the question is, what was still in the public domain in 1998 and therefore was frozen? Well, The Return long since in the public domain. His Last Bow in the public domain. Valley of Fear in the public domain. The casebook, and remember, we're going story by story. The stories that were in the casebook appeared over a 6-year period. First story chronologically in the casebook, The Mazarin Stone, 1921. 1921 plus 75, 1996. Before 1998, it's in the public domain. You could use The Mazarin Stone. You might not want to, but you could. What story was published in 1922? Thor Bridge. Do the math. 1997. Before 1998. Have fun with Thor Bridge. The Creeping Man, 1923. 23 plus 75, 1998. Whoops, and that's the cutoff. The 10 stories between The Creeping Man, 1923, and Shoscombe Old Place, 1927, were the famous 10 stories that you could not use. Now, the Arthur Conan Doyle estate, and I'm not getting into the whole question of who within the Conan Doyle family owns the rights, which was itself a separate and more complicated area of contention over time, but the so-called Conan Doyle estate took the position for many years that even though only 10 of the 60 stories were still under copyright, that was enough that you needed their permission to use the characters. And even though fully 50 of the 60 stories were undisputedly not under copyright, the character, they said, continued to evolve, wasn't fully formed until all 60 stories were written, and therefore you needed a license from them in order to publish a book, publish a pastiche that came onto their radar screen. And what they would do is they would charge a license fee that was low enough that people would just pay it rather than argue. Eventually it was Les Klinger, who many of you know, who decided to challenge this. Basically the position that he and his lawyers took was that this was just nonsense. Yes, you couldn't reprint those 10 stories. They weren't trying to do that. You couldn't use characters from those 60 stories. You couldn't. You shouldn't talk about Kitty Winter. You shouldn't talk about Barker. But if you wanted to use the characters of Sherlock Holmes and Dr. Watson and Mrs. Hudson and the concept of a consulting detective, those features were fully formed in stories that weren't copyrighted, and indeed had emerged in stories that actually were never under copyright, as I talked about earlier. So a lawsuit was brought in. They picked Chicago. Copyright jurisdiction is national. You can bring the lawsuit anywhere the book has appeared, which is generally every district. They brought a lawsuit in Chicago for a determination asking the court to rule that they did not need to pay a license fee to the Conan Doyle estate to bring out a book of pastiches of Sherlock Holmes and Dr. Watson. Les and Laurie King had brought out a previous collection of pastiches. At the last minute, the Conan Doyle estate had written to Random House and said, "You need to pay us $5,000. Random House said, "No, we don't." They said, "Yes, you do." They said, "Fine, here's $5,000. They then moved to a smaller publisher. The Conan Doyle estate said, "We're going to tell Amazon and BarnesandNoble.com and everyone else to blacklist your book unless you pay us $5,000. This publisher didn't have $5,000. They said to Les, "You have to come up with $5,000. Les said, "The hell I will." They bring the lawsuit. And the lawsuit is ruled on by the judge in Chicago, who rules rules against the estate in favor of Les and Laurie King. Goes on appeal to the Seventh Circuit Court of Appeals, where by random draw it's assigned to a judge named Richard Posner. Now, Richard Posner was an interesting draw for this case, because on the one hand, he was probably the best known American judge other than the justices of the Supreme Court. He was a giant of the law. He was originally associated with what we call the law and economics movement, but he'd also written three editions of a book on law and literature. He had written some important copyright decisions, notably one in favor of Neil Gaiman on a dispute he had with Todd McFarlane over some characters in the Spawn series, and was just a fascinating judge to draw this case. He had also, about 10 years earlier, written a book review for the New Republic magazine. He did a lot of extracurricular writing. And he had written a book review of Les Klinger's 3-volume annotated Sherlock Holmes, in which he said, "I don't understand this idea at all. I'm being asked as a judge to talk about whether Sherlock Holmes is using legal reasoning, whether he's using correct police. No, this is children's literature. This is mediocre Victorian children's literature. Why are serious people spending their time on this nonsense? Yes, a teenage boy might get a few hours entertainment or pretending to be in the Victorian, but that's all." And now 10 years later, he's deciding the case. He put all of that aside. He took it very seriously, and he rendered a decision in which he said that the Conan Doyle's estate's decision was, and I'm going to use a technical legal term here, that the Conan Doyle estate's position was wrong, was garbage, was nonsense, that there was absolutely no merit to this idea that you can extend the copyright on public domain works indefinitely merely by writing more works. They said there was no case law support for that, and he actually wrote that the Conan Doyle estate, it was so clear that their position was wrong that they actually were required to pay Les's attorney's fees. He said their business model was extortionate and they should stop it. They tried to take the case to the United States. Justice Kagan denied a stay. The Supreme Court, which has discretionary jurisdiction, turned the case down. You'd think that was the end of it. Not necessarily. There were two more lawsuits. In 2015, they challenged Mitch Cullum's A Slight Trick of the Mind and the movie Mr. Holmes that was based on it. And a few years later, they challenged the Enola Holmes books by Nancy Springer and the Netflix series that were based on those. And the theory was, yes, okay, we lost. The theory of the estate was, yes, okay, we lost. We understand that only the last 10 stories are protected, but we think that these films are wrongfully using elements drawn from those last 10 stories. For example, in the Enola Holmes books, Sherlock Holmes is respectful of women, where this is a trait the estate claims that only arose in the last 10 stories. You didn't see any of that earlier in the canon. Sherlock Holmes was more emotional. You didn't see that until the last 10 stories. Sherlock Holmes liked dogs. You didn't see that until the last 10 stories. Mitch Cullum writes about Sherlock Holmes retiring. Well, that's a creature of the last 10 stories. Now, there were a lot of problems with these theories. Both of these cases settled, by the way, so the courts never ruled on them. And I'm told, although the settlements are confidential, I don't think huge amounts of money changed hands. There are a lot of problems with these theories. For one thing, they're factually wrong. I mean, the very first short story is A Scandal in Bohemia. You talk about Sherlock Holmes being respectful of women, that's nonsense. The idea of Sherlock Holmes retiring is discussed in The Second Stain. It's discussed in His Last Vow, obviously. It's not a creature of the last 10 stories. It's just factually not accurate. Even if it were, it's not a good theory. You need a certain degree of creativity and inspiration. The idea that a character gets old and retires is not protectable, copyrightable subject matter. The idea that a character is more emotional than he used to be is not copyrighted. So these cases, but still, everyone who was doing anything, or at least anything commercial with Sherlock Holmes, had to worry about this. Well, eventually the 20 years expire. Beginning in 2019, works start going into the public domain again, year by year. The Supreme Court upholds the 20-year extension in a case called Eldred. They say, yes, the Constitution doesn't specifically say how long the copyright can last. It does have to last for a finite amount of time. The Constitution says Congress has the right to protect the works of inventors and authors for limited times. But how long should the copyright be? That's a policy question, and you can debate both sides of it. You want it to be long enough to incentivize people to create works. If there were no copyrights, people could not necessarily make a living as an author, as a playwright, as a composer. There need to be copyrights, but there needs to be some reasonable amount of time. And how long it should be is debatable. Mark Twain and Rex Stout used this analogy too. Rex Stout for many years was president of the Authors Guild and testified about copyright. He said, if I build a chair and it's a sturdy chair and my grandchildren want to sit in it, no one from the government is going to say, okay, you have had that chair long enough, it is now a public chair. Why, if instead of my creativity being with a hammer, hits with a typewriter, do I have less rights? And there's a certain amount of truth to that. On the other hand, if we wanted to put on a production of Hamlet, it would be kind of difficult to track down who Shakespeare's heirs were and get permission from them. So obviously there needs to be some length of time. The argument was that extending it from 75 years to 95 years was too long. The Supreme Court said no, that's a congressional judgment. We'll let this, but you really are kind of pushing up against the limit. Between that and a feeling that there was pressure from libraries, there was no serious attempt made to further extend the 95 years. Even Disney and Mickey Mouse and Winnie the Pooh gave up. And so between 2019 and last year, the last 10 stories entered the public domain. All of Sherlock Holmes is now, by expiration of time, in the public domain in the United States, and I believe everywhere else in the world. I think we were the last holdout. Not quite all of Sherlock Holmes, of Conan Doyle, is in the public domain. If you'd like to publish The Complete Professor Challenger, wait another year and a half. Conan Doyle died in 1930 plus 95. Wait till the end of, as of 2026, all of Conan Doyle will be in the public domain. His last few short stories, his last Professor Challenger novel, etc. But in terms of Sherlock Holmes, you don't need to worry about the Conan Doyle estate anymore, at least on the copyright side. They've made some noises about trying to protect trademarks. They have been stopped from protecting trademarks in the realm of books and magazines. There is a Supreme Court case that says you can't take an expired copyright on a character or on a story and protect it forever, because trademarks do not have time limits. Coca-Cola will own the trademark on the name Coca-Cola forever as long as they continue to use it. You cannot extend the copyright forever by calling it a trademark instead. If you want to publish a pastiche, you should not have any trouble on the trademark side, and indeed Les and Laurie objected when the Conan Doyle estate sought to trademark. Trademarks are by different classes of goods. When they sought to trademark Sherlock Holmes in the books and periodicals class, Les actually objected. They had to withdraw that. But they do hold trademarks that haven't been challenged in the realm of video games, in the realm of apparel, in the realm of footwear. If you're planning to market a Sherlock Holmes video game or a Sherlock Holmes t-shirt, or one that's a little troubling is exhibitions. I don't know what that means. If you're looking, get legal advice from a professional. But to publish a book or a magazine, you should be okay. So that's the story of Sherlock Holmes and the canon in the United States in 1,000 words or more. Questions?
What motivated the Conan Doyle estate to pursue this when they pretty much were short of failing?
Well, they didn't think they didn't think they were short of failing. They seem to be. I mean, some of you may know a couple of people who were involved. I don't want to get into personalities, and I didn't know them personally. But I think I think that there were some distant relatives involved who may have thought that they did have a moral right to get some compensation from their ancestors. No one, Conan Doyle has no living direct descendants at this point, but he has a fair number of collateral relatives. And then there were people who were trying to monetize it. The feeling was that we're not asking for exorbitant amounts of money, and it's only fair for people to share. And a lot of people, as I said, went along with it rather than get into a confrontation. And when it was analyzed closely, as I say, it was decided that the emperor had no clothes. But if some of those people were still around, and some of them are still around, some of the people who were expert witnesses before the case is settled, the parties exchanged affidavits and exchanged witness lists. There are some deceased, but some still living, prominent irregulars who signed affidavits on behalf of the estate, saying that we think that there are sufficient contributions of new thoughts and new concepts within the last 10 stories, that there should be this degree of protection. There are irregulars who you would know who took that position. Why they took that position, you would need to ask them. As I say, moot now because even if it had been a meritorious theory, it's gone now by lapse of time.
If originally, instead of copywriting, could they have trademarked it and kept it forever, or is that?
The answer is it's not. That is an area that's not as clear. I mean, I said at the beginning, most of these things were fairly clear cut. That's one that's actually not.
Right.
As I say, there's a Supreme Court case. It involved very eccentric facts. It involved the film Raging Bull, but that says that you can't really take. You shouldn't be able to take the name Sherlock Holmes and say, okay, you can't, if you're going to republish the Sherlock Holmes book, you have to change all the names. Or if you're going to write a pastiche, you have to write it under different names. You can't leverage, a copyright into a trademark. For other things, for other types of goods, maybe you can. The leading practitioner, the leading proponent of using trademarks to extend is the Edgar Rice Burroughs estate. If you try to publish anything in Tarzan, you will get a threatening letter from them. People continue to pay them money. At some point there will be a showdown. It hasn't happened yet. And the first Tarzan novel was 1912, so that would also be public domain. I know that because a Rex Stout story appeared in the same issue of the old story, and I can't get a copy of it because the Tarzan collectors have bid it up to $300,000. The short answer is it's not clear exactly where that line is drawn. I don't think you can do that, but ironically, the Conan Doyle estate and the Conan Doyle heirs came to the realization that they should at least be trying to trademark Sherlock Holmes relatively late. And believe it or not, for all the craziness, for all the obnoxious correspondence that we've all seen from Adrian Conan Doyle and Dennis Conan Doyle and A.P. Watts and Sons on their behalf, and I've been through a lot of the archives. I've seen 10 times more of it than you. In spite of all of that, they never made a trademark claim in those days, and so they were held not to have protected the trademark. They should have been more litigious, believe it or not. Questions? Yes.
Okay, you use the example of people paying like $5,000 to the Doyle estate. Was that a set sum, or did it vary by who asked for what?
I'm sure it varied. I expect it was negotiable. I took that particular factoid from the complaint in the Klinger case, so that's what they wanted for an anthology with with a print run of a few thousand copies. Whether could it have been less, could it have been more, I can't say. My favorite moment in these lawsuits, by the way, they had to exchange witness lists, and in the Enola Holmes case, Nancy Springer. They put Millie Bobby Brown on the witness list. They were going to ask her whether she was using protected character elements for post 1923. She's a very bright actress. The idea of making these movies was actually her idea. She went to her agent and said, "I want to play," as a 15-year-old, and said, "I want to play this part." That's why those movies were made. But I don't know what she would have had to testify about. Fortunately, the case got resolved.
Yeah.
The Conan Doyle estate is really not an estate as we think of one, right? Is it more?
No, it's a corporation, but it has succeeded to whatever rights the Conan Doyle heirs collectively have. There have been assignments, as I say, the whole area of who within the Conan Doyle family owns which rights is an independently complicated. It's a whole 30-minute talk that Betsy should give, not me. For many years, there were some distant relatives involved. Lady Conan Doyle, Dame Jean Conan Doyle, Sir Arthur's daughter. We captured the rights. There was a provision where if you assign rights to a publisher, for example, after a certain number of years, the family members can claw them back. She recaptured the rights. There was a distant relative named Andrea Reynolds who was claiming to own the rights for years. She didn't. Her claim was trumped up, but she was creating all kinds of confusion. But no, the Conan Doyle Estate Limited is a company, but to the extent there are legitimate rights, they are the American owner. If you wanted to publish tomorrow a story that Arthur Conan Doyle wrote in 1930, they are the people who you need to legitimately go to for permission for another year and a half.
If I could just add something.
Sure.
I think that it's fair to say that a lot of this legal structure was established when Dame Jean Conan Doyle was alive in order to protect her and allow her to be able to get whatever money they could from the works of her father. Unfortunately, they